Welcome everyone to the University of Kentucky's Office of Technology Commercialization's November webinar, Why You Need a Patent Landscape Search. I'd like to remind everyone to please keep your mics muted and your video turned off as we are recording and doing live captioning. If you have questions during the presentation, please put those in the chat function. You can either do that to everyone or privately to me, Jackie Green. And I'd like to introduce Matt Upton, who will be presenting today. Thank you.
Hello, everyone, and thank you, Jackie. As Jackie indicated, today we're going to talk about why you need a patent landscape search. One of the reasons we're having the webinar is that for about the past year, since I came on board at the OTC, we have kind of offered a patent landscape search to all of our researchers at UK, but no one knew we were offering this service. So we wanted to have a webinar to let everyone know that we have the capabilities now to do this and why it's important for your research. So what are we going to be talking about today? So essentially, what is a patent landscape search? You'll hear us say that a lot, but what exactly is it? And then two, why do you need one? What benefits is it going to provide you, both now currently and potentially moving forward through your research? And lastly, when you should look to ask for a patent landscape search. So when do you want one conducted? And there's a lot of different options, although there's, I think, one best, and we'll get to that slide. And then after we go over each of these, I want to walk you through one of the tools that we have, going through kind of an example search to see what's involved in this and how we can search so that when you contact OTC, you can have that information ready. We can sit down and have a talk about it, and then we can conduct that search for you and get the best results we can. So first, what is a patent landscape search? Well, essentially, at its core, it's a patent search in a given technical discipline, right? So you have maybe started some research, thinking about some research, maybe completed research, and you want to know what patent literature is out there. So then we focus in on that discipline and can give you the search results based on that. So what does it do? Well, it reveals the past and present activities of various entities in a given area of technology. So when I say that past and present, it doesn't provide the future, right? Hopefully your research is the future of where this will go. But what it does is give us a sense, and you a sense, of what technologies have been, what they currently are, and then from that point we can determine how your technology is different from what's currently out there. This allows us to better plan for prior art. If the end result is patenting, we'll be able to kind of direct things. As far as the scope of a patent search, we can have it be globally, or we can limit it to a specific country or region if that's where the concern is. If you know that the market is only in this area, we can search there. If your research involves something that may be better suited in Europe, we can define our parameters and make sure we're searching there as well. So it can be limited or not. If you contact the OTC and just ask for a search, we're not going to limit it. We're going to provide a global search with respect to how we conduct our searches. So just keep that in mind. And again, so what can the results of a patent landscape search provide? Well, they can provide input on policy decisions, right? At OTC, we have to make decisions on whether or not to proceed with filing on a particular technology. We will always conduct at least a small patent search related to that technology to inform our determination on whether to file. However, that search is always better if it comes earlier, so you can be aware of what may be out there, what potential landmines are out there, and kind of how to find your way through the the patent forest, if you will. It can also help inform with respect to strategic research planning. So if you know you want to tackle let's say a particular cancer, and you want to find out what patent literature is out there with respect to treatment of this particular cancer, then we can go out, run that particular search, get the results back to you, and you can see how other people have tried to approach that disease, and let you know where to avoid, essentially. Another aspect is it can also be utilized to analyze the validity of patents based on data about their legal status. So in some instances, and this may occur even after, if you're working, let's say, on a sponsored research, and the sponsor of the research knows that there's these certain pieces of art that came out or might be a concern, you can get with the OTC office. We can look into that art, do a search around it to see, is that patent still good? Would it have impact on the sponsor's business if the technology you're working on continues? So would it pose a problem? So we can look into that as well. In addition, and the last one, I've saved this one for last because this is the one that kind of gets lost in the shuffle most times, is it can keep you away from an infringement. Now, I know in talks with researchers here at UK, they'll say, yes, but I'm only doing it for research. I'm not selling a product. Unfortunately, unlike other parts of the world, the United States does not have an explicit exception for research. So just because you're researching something does not mean that you're exempt from infringement. Essentially, this has kind of been known since about 2000. There was a court case that was brought against Duke University in which Duke was conducting some research that was infringing another party's patent. Duke made the argument that they were doing it primarily for research purposes, and the court said that's not enough, that the only way to avoid infringement is that if your research is merely for amusement or to satisfy idle curiosity or for strictly philosophical inquiry. Duke's response was, yes, but we haven't made any money. And the court's response was, yes, but by you doing this research, it has raised the level of awareness of Duke University, so therefore you have benefited. So if there's, if you're doing your research into a topic and you come across a patent that you want us to look and see if it has impact from an infringement standpoint, you can absolutely send that to our office and we can take a look at it. So now that we've gone over what a patent landscape search is, well, why do you need one, right? Well, first off is most of the time, our inventors, when they're doing the research, they are focusing on developing a manuscript to attempt to get publications, right? And in those references, they typically go out and do a pretty extensive literature research. However, published papers do not include all prior art. So under the definition from the United States Patent and Trademark Office, prior art is anything that has been printed prior to your invention being filed. So that means anything. A dissertation on a shelf in a library in let's say Hungary would count as prior art, even though no one has ever even checked it out. It's just sat on the library, in the library shelf. But 99% of all rejections at the USPTO are based on prior patent applications. Sometimes they will go out and do literature searches, but most of the time it's based on patent literature. So just because you haven't seen it in a literature search or haven't seen a product out there or know of no treatments like it, doesn't mean that it's not out there. Doesn't mean that someone hasn't filed a patent and it's just sitting somewhere and it maybe never became a patent on its own, or maybe it became a patent, but no one had funding to move forward and create a commercial product with it, never published a paper on it. So just because you haven't seen the literature does not mean it's not in patent literature. In addition, what the patent office will do most of the time whenever they base a rejection is they will combine 2 or more references, right? So what the patent office does with this respect is say, yes, there may not be a reference that discloses everything you're doing, but in terms of a pharmaceutical, they may say, well, the pharmaceutical was known, you're having a different method, but it's also known that pharmaceuticals having similar structures have been used for what you're using it for. And they'll combine the known pharmaceutical with your novel use of it from a similar drug and say that you're rejected. So anytime you get a search, we pay particular attention to that in the results that we provide, so that we can kind of point out that, well, they may take this reference plus this reference, so how can we overcome that? And it can be done in a couple of ways, but we can kind of provide that roadmap and help you look at those references from that standpoint that they may be combined. One of the ways that they combine it is this thing known as a FOCITA. So the patent office looks at whether or not to combine references as a person having ordinary skill in the art. Meaning, what is the typical person that would be involved in this type of research? What is their level of education? And then we take that ordinary person and what would they have known to combine? And it's that hurdle you have to overcome in order to get allowance, right? More than what a person of ordinary skill in the art would know, right? There has to be this inventiveness that comes along with it that is beyond, yes, of course, a person having a PhD in pharma would know, they wouldn't have known to combine this and this for this treatment or to create this structure and it would have this effect. That's kind of what we have to overcome. In addition, one of the, I think most important things in a search that it's often overlooked, it helps with distilling your novel feature, right? So a lot of times during research, it may be, research into a novel compound, a new device, a new method of doing something. And we know that, it may be based on other work, but there's some nugget that is different than anything that has come before. And when we sit down to talk about what our search parameters are, that's what we're trying to dig down to. We're trying to dig down to what is that nugget of novelty that we need to search around. And just that conversation alone helps identify the direction we need to take any associated IP down the road, right? By focusing in on, well, this is the aspect that no one else has ever talked about, right? And that comes through, one, talking about the invention prior to the search, just to find out what we need to search, and 2, seeing what those results are in comparison to what that novel feature was, right? There's been many times I've conducted searches and we thought, component A was the novel feature, but it turns out it was this other component C that was actually never mentioned anywhere that makes everything work more efficient. And that was actually the driving force behind the novelty. Another thing it does is helps with time and cost savings, right? If you know what's out there, you know what to avoid. That can help in terms of time. With respect to cost, you didn't have to waste grant money or whatever it was going down this road because you knew that there was a patent out there. You could focus your time and energy in the grant monies on research that will benefit based on the search's results. In addition, it can also it provides guiding and prompting to additional inventive features, right? So if you get to, if you're going through your research and you realize that, hey, every search we've had has this, but I think it'd be really good if it did this additional thing. Well, that's an additional feature that may come about as a result of that search, right? We've noticed a hole in the prior art that there's room for this additional innovation. And if you can incorporate that into your research, into the final technology, one, that may give us the ability to get allowance, but two, it was something that was kind of guided and noticed by having that search done. Another benefit of having a landscape search done is claim scope. When I say claims, let me give a little explanation of the body of a patent real quick. So typically you have a description that describes everything about your invention. However, the portion at the end known as the claims is actually, if you think of IP as any other property, your claims are actually building the fence that you have around your intellectual property, right? It is the area you are protecting. It is the area that you can prevent others from trespassing upon. So what a patent landscape search does is, again, kind of lets us know that pathway through the forest of patents where we can build our little fence, and the results of that patent search may give us some insight onto how much area we can try to capture within that fence, right? So it gives us a strategy both from marketing aspects and from claim scope to let us know how broad we can make this. And typically the way this works in practice is we go through the process, we sit down, develop this nugget of novelty. Then we move from there to do the search. Then we find the area around that nugget. And then if we focus in and provide that novelty aspect, we can then broaden things around it, because we know however broad we get, as long as we have that one novel feature in it, we're going to get an allowance on it. So it lets us broaden things up considerably. So that's essentially why you need a patent landscape search. But then when should you ask for a patent landscape search? And the simple answer is the earlier the better, right? And there's a couple reasons for this. So although it can be beneficial during any stage of research, the reason it's better in the beginning is, right, it's providing a roadmap, letting you see what's out there. So the earlier you have access to that map, the better. In addition, the earlier you do this, this may also be an ongoing process. Before research begins or before any experiments are run, we can run this search, kind of let you see what's out there. As your research moves along and the research is kind of dictating the pathways or what will and won't work, you can also come back to us once you determine, you know, that this is the pathway you have to go based on the research. We can come back and conduct the patent search again based on this new understanding and provide a new roadmap, right? So don't view this as a one and done. This can be we can run patent landscape searches multiple times. And it's even beneficial if you're just curious about a particular technology, right? You may have thought about this area, thought that maybe this would have, some research you're doing over here may apply to this problem. And just to get a sense of what's out there, you can contact our office and we can run that search to see if anyone else has thought of using a particular technology to solve some other problem. So I view this as like a continuum, right? I think the earlier you have searches and the more searches you have, the more it benefits you. The longer you wait, the only entity it's benefiting is essentially OTC, right? When you submit an invention disclosure, we're going to run a patent search to see what's out there in order to make our decisions internally, and we're going to do that anyway, and that's when it benefits us. So if you wait till that point, that's essentially where it benefits OTC, and not you so much, other than letting us know, has this already been done? But the earlier you do it, the more it benefits you, because it provides insight into the research you're conducting and may kind of drive what experiments you're doing, right? One instance that we have done these is it has turned up similar art, but it allowed us to go in and look at those applications that were similar and see why they were rejected at the USPTO. And then we can take that information, relay that to you so that you know, hey, these are the experiments that the USPTO is looking for. And with that insight, go out and run those and give you a better chance of getting allowance at the patent office. So, like I said, it can be done anytime, but the simple answer is the earlier the better. And the earlier you start, potentially the more patent landscape searches we can do for you. All right, so that's essentially what they are, why you need one, and when you should ask. So I wanted to run through one because I understand that a lot of our researchers at UK may have access to things like SciFinder and other resources where they can search patent literature. And I know that there's Google Patents out there and a lot of other websites that allow you to search. I'm not going to tell you definitively Google Patents is bad. I can tell you that before coming to the University of Kentucky, I worked as a patent attorney in-house for a chemical company, and none of our searches were allowed to be conducted on Google Patents. The reason being is you're talking about Google that is a known collector of data. And presumably when you are conducting a search with a platform such as Google Patents, you are conducting that search based on something that should be kept in secret or confidential. And now it's kind of this two worlds butting together. A company that one of their sole purposes is to collect data, and you're inputting data into a search string that should be confidential. Now, I have no proof, but I can tell you that the company I work for was adamant against running any searches through Google Patents. But at the OTC office, we have a subscription-based patent service called Innography that we use to conduct our patent searches. There are a couple of paid patent services out there, Innography being one of them, PatBase being another, that are kind of a step beyond where Google Patents is. So what I want to do now is kind of run through what a search would look like and kind of go over the results and see what you would get. So here's one. So this would be for a new class of compounds to treat drug addiction. So researcher in this example provides us with a chemical structure and then the name of the structure, 2-phenylethyl 1-phenylpropane toluamine. Yes, I do have a chemistry background, but yet saying words like that still intimidate me. So with this, we have a couple different options, right? So this is our, search page for our Innography tool. So we would go in and we have a couple different options. One, to search things such as drug addiction, drug treatment. We have the chemical structure and we have the actual chemical name. So if we're looking at what the inventors believe is a new compound, then what we need to do is focus in on that because that's where they have derived this novelty from the initial meeting. So what Innography allows us to do, if you'll notice, I don't know if you can see my pointer or not, but in the left corner it says you search patent keywords for, and that's where we could put in the actual name of this compound. So with that, we ran this search and it came back with only 4 results. That is not a very definitive patent search. 4 results may let us know that people have not used this term. And because of the algorithm that Innography uses, you can see the relevance on the right side, the top being 87%, which indicates to a searcher that actual chemical compound was not found within any of these. It just has a lot of words in common with it. So with that, searching under this chemical name is not very effective. And this would likely be true on things such as SciFinder and the like. So now we need to rework this. And another thing we know about this compound is that the compound works through as a vesicular monoamine transporter 2. So it works through VMAT2. So running that search it comes back with 30 results. Again, now we have more and there's more to look at, but that's not really the search we're after. 30 indicates that our search isn't broad enough. We're not capturing enough of the art. The one good thing that we do notice on this search is that a lot of the results now are coming up with the University of Kentucky. Why is that good? Because, well, in this example, this is something from the University of Kentucky. It's something that's already filed. So I would expect research that has already been done, that I know has been done, to start coming up in a search like this. So now it starts coming up. But 30 results just isn't enough yet. And I believe the next slide shows, and this is also a nuance of patent searching. So we search the vesicular monoamine transporter 2 that one of ordinary skill in the art would know would be called a VMAT2. So what happens if we just search for VMAT2? Well, now our 30 results go to 622 results. So essentially searching for the same thing using different nomenclature has vastly different results. With VMAT2 actually spelled out, we're looking at 30 patents, whereas if we use VMAT2, now that search pool has expanded to 622 patents. So now this is more like something we'd be interested to dig in. So that's one method we could use to do this. And then we could further refine that by going VMAT2 and then going down into drug abuse and specifically what type of abuse, psychostimulants, things like that, that we're looking to try to have a method treatment for. But what Innography also allows us to do, similar to things such as SciFinder, is also search patent literature specifically for compounds, right? So you'll see here, it's the same search, but we're searching for chemical structure. We're looking for exact match in essentially the title, abstract, claims, description, or clippings of patent applications. So we're trying to search everything that's in a patent application to see if we can find this chemical compound, to see if it's been done before. So when you look at the exact match, only one result comes up. So again, that's not telling us a lot about what the patent landscape is, so we need to change that search a little bit. So with this search, we've changed it from, instead of exact, to partial. So the program runs its algorithms to determine, is there a part of this compound that has been described or talked about or has an image shown in various patent literatures out there. And as you can see, our number has gone from one result to over 19,000 results. Now, again, on the opposite side, this is too many results, right? So 19,000, we're not gonna be able to look through all of these. But from this point, we can start adding keywords in again, such as, drug abuse, amphetamines, things like that, to try to get a sense of what's out there. But looking at the results that came back from this and kind of what this program is returning to us. So now here's that same search with the compound, but now we've put in methamphetamine, right? Because that's one of the focuses of this technology, is a method of treating the abuse of methamphetamine. So now when we type in that, now we're down into 2,000 patents. So from this, and combining with this smaller number and the relevancy score over on the right, we can start looking through some of these patents to see, are they close? Are they not? Why is this being returned to us? Is it something we need to be worried about? So from this, I picked the second highest one at random and started to look through, and now you can see this was the chemical species that was kind of described a lot in one of the patents that came up in the search. And although it is similar, it does have the two, functional groups on the ends with the rings. It does have the double bonded O and the O in the chain. So from a patent search standpoint, yeah, this is close, but not something that would be problematic. And yes, I did specifically pick out this kind of chemical compound structure to kind of show, work the way through. And this kind of matches up with what we've seen, because patents that UK has filed based around that structure and kind of other structures on that same backbone have been allowed at the USPTO. But this was kind of, the behind the scenes on how those searches were conducted leading up to that, to make the call to, yes, we'll file, yes, we'll try to get patent protection on this. But at this, at any phase during the research, it would be helpful to look at these results from various angles to see what has been done, what is out there. Yes, there's things that are close, so now I know, all right, I can have this general structure, but I need to avoid a double bonded O off the chain or incorporation of the oxygen within the chain, and I've separated myself from art like this. So now that we've looked through one of these searches, and this, I did pick out a pharma one because I will say that the majority of the patent application invention disclosures we get at OTC come out of pharma. So we do have the capabilities to search, but don't think that it has to be pharma. So if you have a device, we can do the same type of searches. Yes, we can't search compounds, but we can go through, search your device, search the elements of the device, see what's out there. So after we've gone over that and the fact that this service is available, so how do you request one of these searches? Well, simply contact OTC. Specifically, get a hold of me. So my email address is matthew.upton@uky.edu, and there's my office phone number. I will say email is probably the best way, considering I do have issues with my voicemail trying to get them from off campus. As you can currently tell, I am not on campus. And then depending on that technology or what you provide for that initial search request, we may arrange a meeting to discuss your invention and any prior art that you know of, right? One of the reasons is if you're aware of a patent and say, hey, can you just get me everything that is similar to this patent? We can absolutely do that. Innography has an algorithm. We can literally type in that patent, hit a button that says more like this, and provide you with a list of relevant patents to that technology you're specifically looking at. Another reason for the meeting is, as I said, one of the main important things of having a search, one of the benefits of it is trying to drill down to what is the novel aspect of your invention, right? So that initial meeting, we can sit down, discuss what you want to do, discuss where we think the novelty is, and then that's what we can search around. So that way it gives us the best return for the search. And then typically, what is your results going to look like? Well, typically, depending on what you want to have done, but if you just get a hold of me and say, we're planning on doing this research, here's what we're doing, what can you find that's close? Well, typically then we'll go out, conduct the research, and then we'll include references back to you that we think are relevant, and then just ask you to review those results to see if these are close or not. And then based on that result, we can have a follow-up to fine-tune the search if it's necessary, right? If we come back and say, we're getting all this stuff, but the search terms or the way that we search kind of went off in a different direction, we can address that, kind of reel it back in, maybe adjust the keywords that we're using, and can run that search again for you. But we'll typically give the references and why we thought it was relevant to the technology as you described it. And as I mentioned before, this can be an ongoing process, right? So it's not like you get one shot at a patent search from OTC. Over your planned research, this can be an ongoing thing. We run a search early in the beginning. You come to a decision point, you have another one. Your research kind of veers you into another direction. You can have another search done. And I think there's value at all of those points to have a search done. And with that, I think that is it.
Thank you so much, Matt. Appreciate it. We do have some questions and want to remind the audience, if you have a question, to please put those in chat and we'll ask them. Our first question is a really good one. Matt, can you tell us how long it typically takes to complete a patent landscape search?
Yeah, so it varies depending on the technology. So if it's a simple mechanical device, it may be quick. If it's a compound device, such as what I ran through, that's actually probably a little quicker. If it's new methods of treatment, or maybe a library of peptides, or a method of doing something, it can take longer. Typically, it's going to range, and it's a pretty big range. So anywhere from 2 to 20 hours of research time, which is about typical for a standard search if you'd have it conducted by an outside search firm. So max out at about 20, but it could take about the example that I did. I wasn't here when the original searches were ran, so I went out and ran them, and I got done with it to what I thought was a satisfactory level in about 3 hours. So you're looking anywhere between that range, about 3 to 20 hours, to actually run the search, get the results back to you. So, you're looking at, anywhere from a day to get the results back to longer if it's a 20-hour search.
Does OTC have translations of foreign patents?
Yeah, so when we're looking at patent results, they can come in from Europe, they can come in from Japan, China, Hungary, all over the world. So Innography does provide translations. Now, unfortunately, not all patent offices have English translations, so I may not be able to send you a PDF, but I can cut and paste excerpts or the entire patent out of Innography in an email to you, or maybe put it in Word and then PDF that and send it to you. But Innography does have translations into English from most patent offices across the globe.
So if I have a patent that I'd like OTC to review, will OTC do that?
Yeah, as I mentioned, if you're aware that there may be art that's close and you want to know exactly what that art covers from a patent standpoint, then we could absolutely review that and let you know kind of what it covers. The reason it's important is most of the time in academia, we're used to looking at papers, and a paper covers this, and they have some small area, and they have research on that small area. Whereas patents, as I mentioned, patents are written from the standpoint of trying to capture as broad an area as possible, right? And they're not written by scientists most of the time, they're written by attorneys that know the language that they have to use based on years of court cases to try to get as broad a coverage as possible. So sometimes it's not always clear exactly what a patent is covering or saying with respect to what it's presenting and where the meets and bounds of that patent are. So we can absolutely take a look at any patent that you have and are concerned about.
Another question, is the patent landscape search service available to Kentucky businesses that are not connected to UK?
To be honest, I don't know. That would be a question I would have to look at. I know that for our researchers, it is a tool we provide. However, because OTC is part of the University of Kentucky, I guess it would depend on if there is some type of relationship there. In addition, it also has to be said that even if that answer was yes and we provided a search, that searches always come with a caveat, right? Searches are, and this goes for searches done at OTC or searches that are conducted through outside professional search companies, is that no search is 100%. No search can guarantee you'll get a patent. And if we did it for some entity outside of UK, there would have to be some type of acknowledgement of the limitations of what searching can provide. But that is definitely something I can look into to see if it is available for businesses outside of UK that don't have a relationship otherwise. Now, for companies that are licensing our technologies, I know we have done that. But if there is no connection, then I would have to check and see on a case-by-case basis.
Matt, we have another question. Can you talk about any drawbacks there are to having a patent search conducted?
Yeah, so anyone that has filed a patent application through OTC has experienced the email that has come back and said, yes, thank you for your manuscript. We have everything filed. Now we need to complete an IDS, and you need to let us know which of these references are relevant to your work. That is a requirement from the USPTO that if an inventor has knowledge of relevant prior art, it must be disclosed to the patent examiners. Whenever we conduct a patent search, anything that is deemed relevant will have to be submitted to the patent office. So traditionally in patent law, there have been two approaches. If you know that, depending on your familiarity with a particular field, if you know that things aren't there, some patent practitioners have been leery of conducting a patent search because anything that's discovered has to be turned over to the patent office, and that could affect patentability because the patent examiner may have a different view of that reference than the inventor or the patent attorney. So it could negatively impact your chance of allowance by essentially doing the examiner's job for them. However, I've always taken the opposite approach, is that my goal is to not put out patents that are subject to challenges from prior art. I would rather put out patents that are aware of what challenges are out there and drafted from a standpoint to get around those challenges, because I think it builds better prior art. But any results that we did find relevant, we would have to turn over to the USPTO.
Thank you, Matt. I think that was our last question. Would like to thank everyone for attending and remind you that we are recording this, so we will be putting this on our YouTube page in case you want to watch it again or share it with your colleagues. Our next OTC monthly webinar will not be till February, but we will be featuring the National Institute on Aging, and they will be talking about their SBIR and STTR opportunities. So we hope you'll join us then. Thank you, and we appreciate you coming.